Now that we have a good idea of how the shareholders take action and their role in the decision making of the corporation, let's talk about the board of directors and how it takes action and how, what its role is in the decision making of the corporation. All right, so the board manages the business and affairs of the corporation. Right? So that means the board has the powers that the corporation has. This is just a list of few of the things, but the board, the corporation, can buy or sell products, can buy or sell assets, it can make investments, it can appoint officers, it can hire employees, it can hire independent contractors. The corporation and the board of directors can sell stock, it can borrow money, it could lend money. The board of directors can declare dividends, right? And we understand what a dividend is. That's where you distribute the profits to the shareholders, etc. Any powers that the corporation has, it's the board of directors who makes the decision to use those powers. There are a few matters, as we've discussed, that the board cannot take, a few actions that the board cannot take without shareholder approval. So my mnemonic device was MADs plus bylaws. So for mergers, amending the articles of incorporation, dissolution, and sale of substantially all of the assets, the board needs shareholder approval. We'll discuss this in greater detail later in the course. Now, there are some powers that the board and the shareholders share. Number one, amending the bylaws. We saw that the board has the power to amend the bylaws without shareholder approval. We also saw that the shareholders had the power to amend the bylaws without board approval. And if there is a tie, right, if they each want a different amendment, then there are mechanisms where we can make sure that the tie will go to the shareholders. We talked about that just before. Also, filling vacancies on the board. This is a shared power between the directors and the shareholders. So if there's a vacancy on the board of directors, the shareholders can fill the vacancy or the board can fill the vacancy. Why might there be a vacancy on the board of the directors? Well, we might have a director pass away, or we might have a director get sick and resign, or we might have a director resign for another reason, or we might expand the board. Originally we had 9 members on the board, we expanded the board to 11. Well, now we have to fill those 2 vacancies. Who fills the vacancies? The board can either appoint new directors to fill the vacancy, or the shareholders can elect new directors to fill those vacancies. Which one will happen? Well, usually because calling a shareholder meeting is a big deal in many corporations, so it's easier for the board to fill the vacancies. Now, the people who fill those vacancies just stay in that position until the next election, and then the shareholders will get to either re-elect them or elect new directors. The directors are not agents of the corporation, right? Remember what we said an agent is? An agent is someone who has the authority to act on behalf of the principal. In this case, the principal is the corporation, and bind the principal, bind the corporation. The directors indeed do run the business and affairs of the corporation, but as a body, not individually. So no individual director can act as agent, right? So let's say it this way. Your status as director alone does not give you authority to bind the corporation. Where does agent authority come from? Well, or where is it? Usually it's in the executive officers, the other employees, or maybe the corporation will give authority to a director or a shareholder. But just simply because you are a director does not give you the right to bind the corporation, to act on behalf of the corporation. Once again, we will discuss agency authority in greater detail a little bit later. Let's talk about board meetings. Very simple. There are regular board meetings, right? You may regularly schedule a board meeting once a month. If you have regularly scheduled board meetings, you do not have to give advance notice to the directors about these meetings. If you have a special board meeting, right, for some reason there's some matter, we have to get together and decide this or discuss it, then you have a special board meeting, and that requires advance notice. Here are some quick points about board voting. First, proxies are not permitted, usually. Remember, we talked about shareholders, and that shareholders can vote by proxy. They don't have to actually attend the meeting. They can give authority to someone else to attend the meeting on their behalf and vote their shares on their behalf. Directors cannot do that. A director cannot say to another director, here's my proxy, I won't be able to attend the board meeting, please vote on my behalf. This is generally not permitted. A board of directors can take action by written consent without a meeting. So if there's a matter and they feel that it doesn't really require discussion, or maybe they've discussed it outside of the board meeting and they want to vote on it without getting together and having a meeting, they can take action by written consent without having an actual meeting. Each director gets one vote. So, for example, I might be a large shareholder. I might hold 75% of the shares. I elect myself to the board of directors. On the board of directors, I only get one vote. So all the other directors also only get one vote. And when directors vote, usually they approve an action by a simple majority, at least for ordinary matters. So that means that they just have to have more yeses than nos, and the matter is approved.